This is part 56 and the concluding part as far as our lecture series on Criminal Procedure Code of 1973 is concerned. In order to understand Criminal Procedure Code, as I told you right in the beginning, we have to start right from section 1 and go up to section 484, which are divided into 37 chapters of the Criminal Procedure Code. But simultaneously along with this, it is must for you to know the importance of the first schedule and the second schedule of the Criminal Procedure Code. What is the importance of it with which you are dealt during the course of our lectures? I have tried to go through all the chapters of the Criminal Procedure Code as and when it was necessary and possible by at least making mention to those chapters. For example, when we were dealing with trial, there we learned that presence of the accused person at the time of the trial in order to observe the principles of natural justice is must, unless it is dispensed with by the court of law. Now, how it is possible for the court of law to compel appearance of an accused person in a court of law? If he is released on bail, the court will follow the procedure which is laid down right from section 61 up to section 90 of the Criminal Procedure Code as far as processes to compel appearance of such a person in court of law is concerned. But if he is in jail, I had drawn your attention to the chapter 22 of the Criminal Procedure Code, which deals with attendance of persons confined or detained in prisons, for which you have to refer to right from section 266 up to section 271 of the Criminal Procedure Code. Now, whenever there is an inquiry or the trial, evidence in inquiries and trial, what is the manner in which it is to be recorded? And for that, you have to read right from section 272 up to section 299 of the Criminal Procedure Code. I have not dealt with these sections in isolation or independently, but at the time of the trial, I had drawn your attention. What is the manner in which evidence is to be recorded as far as the trial before court of session is concerned? The role of interpreter. The court has got power to issue commissions for the examination of witnesses, for which you have to refer to right from section 284 up to section 299 of the Criminal Procedure Code. So this is the chapter to which I had drawn your attention. Now, general provisions as to inquiries and trial is dealt right from section 300 up to section 327 of the Criminal Procedure Code. And there we have learned with many provisions at the time when we were dealing with trial. Most of this provision to which I have referred to at the time of dealing with trial before a court of session. And then I told you that, well, the same provisions are made applicable whether it is a trial of warrant cases by magistrate or trial of summons cases by magistrate or summary trial. So there are some chapters or some sections which are common. For example, during the course of the trial, if the accused person becomes a person of unsound mind, then we have to refer to right from section 328 up to section 339 of the Criminal Procedure Code, which deals with provisions regarding accused person of unsound mind. So I personally feel that if you go through the book that you have to refer to is the Code of Criminal Procedure Code 1973, and if you just refer to the bare act, that will serve the purpose. But those of you who want to know everything in detail, I have tried to make your fundas clear. Now, in order to know the details, you can refer to any one of the book, and instead of telling name of any one of the books, you can refer to any one of the books that is available in the library which likes you, because of which you go on understanding the provisions with which you are supposed to deal from the point of view of understanding the provisions of the Criminal Procedure Code. This is also the time for me to tell you that during course when you are learning criminal procedure code, every now and then there is reference to the provisions of the Indian Penal Code because of the relationship between Indian Penal Code and criminal procedure code. Hence, to understand criminal procedure code, it's impossible for you unless you refresh your memory regarding Indian Penal Code. Then only it is possible for you to understand the provisions of the criminal procedure code, otherwise not. In order to understand the importance of the trial along with Indian Penal Code, this is also the time for you to refer to the provisions of the Indian Evidence Act. So you will have to refresh your memory regarding Indian Evidence Act 2 for the purpose of understanding the criminal procedure code with which one is supposed to do. I have tried, for example, when the statements are recorded by the police during the course of investigation, what is the evidential value of it? It's not a substantive evidence, but that can be used for the purpose of contradiction as far as section 145 of the criminal procedure code is concerned, but that cannot be used for the purpose of corroboration as far as section 157 is concerned. When we dealt with the judicial confession, what is the importance of it with which we dealt? When we were dealing with joinder of charges every now and then. So once you read the bare section, at times when the illustrations which are given after the section are required to be read, and whenever there is reference to any one of the sections of the Indian Penal Code, mind well, unless you know meaning of it, unless you know that particular section, namely the offence which is defined by that particular section of the Indian Penal Code, it may not be possible. So if you straightway start reading only criminal procedure code, it may not be possible for you to understand criminal procedure code in the absence of understanding the importance of the Indian Penal Code and the Indian Evidence Act. During course of time, as and when it is required, you will have to have reference to the provisions of the constitutional law also. When we talk about criminal procedure code, then it has got reference to what? It has got reference to 7th schedule of the criminal procedure code, 7th schedule of the Constitution of India, and there you come across what? List 1, which is union list, list 2, which is state list, and list 3, which is concurrent list. So you come across the matters which are enumerated as far as these lists are concerned, and if it falls under the union list, it is only the central government which can make a law with respect to the same. If it falls as far as the matters which are enumerated as far as list 2 is concerned, which is what is known as state list, state has got power. And if it falls under concurrent third list, namely concurrent list, then the maybe central government or state government has got power to make law and carry out amendments as far as this is concerned. Now you being a student of law, you must know the amendments that are carried out as far as the central government is concerned, and when you are in a particular state, then you must know the amendment which is carried out as far as that particular state is concerned. With this now, it is also necessary for you to know the importance of Article 141 of the Constitution of India, which says, law declared by the Supreme Court is binding on all courts which are within the territory of India, and hence don't ignore importance of the decisions which are given by the Supreme Court and also by the High Court as far as particular state is concerned. Now there were some suggestions that I should include many more illustrations, and I also should refer to the case law also. But right in the beginning, this is a point of time at which I have tried to make your fundas clear. Now as you go on working out details as far as criminal procedure code is concerned, naturally you may have some questions, you may have some queries, you may have some problems, and then I don't mind if you mail me those problems, and I hope you know my email ID. Then it will, during course of time, if it is necessary for us to have some more lectures for the purpose of throwing light as far as the questions that are raised by you are concerned, no problem, we can deal with the same. But otherwise, for the timing, I personally feel that if you listen to the lectures which are delivered by me, And if you will have the approach of what? Approach of studying the law in the manner in which I have told you. For example, I told you, as far as recording of the confession is concerned, or to implement the criminal procedure code in its spirit and not in its word, at times the directions are given by the High Court as far as criminal manual is concerned, to which you have to refer to. So simultaneously, this is also, as in case, for example, when the police at the time of investigation go to a particular place, they draw what is known as Panchanama. What is Panchanama? Reducing into writing factual situation in presence of two independent respectable inhabitants from that particular locality. And what is required to be done? For that there is a provision. I mean, these things you go on learning as you go on learning criminal procedure code in detail. We had some limitations, no doubt about it. And the one limitation was that, I started, because that was the one limitation, that I had to resort to only delivery method only. There were no interactive sessions as such. It was not possible for me to meet you in person, but then also I have tried my best, and then it is because of the response of all of you, it was possible for me to have today this concluding session. In this concluding session, I wish you all the best for everything in the life, and as and when you feel that this is a person to whom you can contact, no problem, you can contact me by giving you on my email ID prof.harish.deshmukh@gmail.com. And then let me assure you one thing, that in your email, if you give your phone number, then it will be also possible for me to contact on phone. If through email, if it is not possible, through lecture, if it is not possible for us to solve your problems or difficulties or the queries, that is also one method to which we shall be adopting during course of time as and when required. So with this, again I take this opportunity to thank you as far as your cooperation. Because of the response, I could finish with the provisions of the criminal procedure code, and then we will continue this association forever. All the best, all the best, all the best.